A very good evening to all of you. It's good to come back to FICCI, as always, and physically be part of an event which we haven't had the pleasure of for more than 2.5 years at least. And it's good to see a lot of familiar faces. Of course, I haven't registered all of you as yet, so pardon me. All the dignitaries on the dais and off the dais. The new Controller General, Mr. Pandit, I can see Malti ma'am here, Dipankar, all the familiar faces. Good evening, ladies and gentlemen, friends. Sheetal and her team from IPTSE, including Saurabh, had come to invite me for this seminar, and I asked them what I should speak on. So basically what they've given me is the IP division of the Delhi High Court. So on this, I actually don't need any preparation. So I was very less stressed after I saw the topic, because we've just been living, breathing this IP division for the last 1 year. And India has actually done something historic after the abolition of the IPAB. So let me just take you all back to what happened in the last 1.5 years. And where we stand today and how I look at the future as it's panning out. So as you all know, there are a lot of youngsters in the hall. Maybe they do or do not know about how this whole thing has come about. So until 1999, the jurisdiction in respect of all, can I request not to take separate images and photos, please, since the official photographers are there. The jurisdiction in respect of patents, trademarks, copyrights, etc., not copyright, patent, trademarks and other IP, was always with the High Court in respect of appeals and original proceedings for cancellation and such other miscellaneous matters, including writs, etc. In 1999, the Trademark Act of 1999, the IPAB was constituted, and the intention when the IPAB was constituted was to create a specialized forum which would have, technical people and also a judicial member who could deal with patent matters and all these matters in a much more expeditious manner. Between the said IPAB got notified sometime in September of 2003, and between 2003 till 2021, that's about 18 to 19 years, we saw the IPAB functioning. It had some very good periods when it functioned under Justice Prabha Sridevan, or even at the end by Justice Manmohan Singh, and for some time before Justice Basha, Justice Ansari. They did try their best, but the problem in the IPAB was, number one, its location in Chennai, and that benches had to be created, sittings had to be held across the country in different cities. The IP offices continued to be located in the 5 cities of Delhi, Bombay, Calcutta, Madras and Ahmedabad, and there was no permanent bench of the IPAB in any of these cities except Chennai. And there was problem of human resource, because a large number of judges and members who used to apply or who were approached were not willing to go to Chennai. IPAB did not have the financial, functional autonomy it did have, but the financial autonomy it had a problem with. Funding autonomy it had a problem. And this resulted in a lot of issues procedurally, infrastructure-wise for the IPAB. And the biggest problem that the IPAB faced was lack of adequate, well-qualified applications for the posts of members in the IPAB. And I've been a part of the process at least on 2 occasions, looking at the applications and helping in it. But I must say that, I think IP is such a lucrative practice that most lawyers who are actively practicing are not willing to give up their practices and go into the IPAB as members. But structurally also there was a problem that they could thereafter not appear before the IPAB, and this held back a lot of good talent from working and applying for the IPAB. So there we are in 2021. It was a complete bolt out of the blue. I don't know, I think there's only one person here who may have known about the abolition of the IPAB, Mr. Raghavendra, who's sitting quietly on the stage. So none of us knew about it, and it just happened all of a sudden. I got a call one evening saying that one of my law researchers found it and told me that the IPAB has been abolished. I said, how is that even possible? It was an absolute shock to all of us. And good or bad, we've moved on from there. The Delhi High Court received sometime in June a large number of cases from the IPAB, and at that time the Chief Justice, Justice Patel, decided to constitute a committee headed by me and Justice Narula as a member to deal with it and how to go forward going ahead. So we had a big task ahead of us. The committee had a big task because we were not sure of what should be the correct way in which to handle IP litigation, because this is going to be a challenge. It has to be something which will work in the long run. It cannot be a slipshod or a ad hoc mechanism which will just be there in place and it will just get disbanded or it will prove to be inefficient. But I must say that the Delhi High Court, all the senior judges and the full court, and including the members of the committee, and of course to the extent possible the government officials who were dealing with us, everyone has put their heads together. I mean, I can say from personal knowledge that we reviewed the rules of at least about 15 to 20 state courts in the US as to how they frame their rules for the IP division, and various other jurisdictions. At least 40 sets of rules were reviewed by us from different countries. And after doing all that, the recommendation of the committee was to set up an IP division within the Delhi High Court. Considering the quantum of cases that were going to be there in the High Court and the expected filings in the Delhi High Court, we said it's worthwhile creating an exclusive IP division in the Delhi High Court. Then we started about the task of making specific rules. We now have two committees. The patent committee, which was already constituted in 2018 for dealing with patent cases, which consisted of Justice Naveen Chawla also. And so we were 3 judges who put our heads together and framed the rules for patent litigations and for the intellectual property division of the Delhi High Court. And these rules are absolutely, up to date in terms of the practices that we intend to adopt. One of the biggest challenges that the committees faced was to make rules for India from the scratch, which was not there before at all, and to make sure that those rules adopted and merged and married all the global practices, the good practices from abroad, but merged them into the existing Code of Civil Procedure and the Commercial Courts Act provisions. So it was a big challenge, how to merge them, how to marry them, not contradicting any of the existing procedures, but making sure that it's efficient enough. So in this, I must say that the intellectual property bar has played a very big role. We used to put up the draft rules from time to time, and the bar analyzed the rules. The lawyers, they used to sit down, put together. We received such copious comments from the intellectual property fraternity, and of course FICCI gave their comments as well. We had industry bodies, we had globally recognized industries bodies like INTA, the World IP Alliance, the Japanese IP group. All of them gave their comments. We reviewed each one of them, incorporated all their comments, and finally, as of April 2022, in March we had a big seminar which was presided over by the Honorable Chief Justice of India and the Finance Minister. who then launched the IP division, which is now an exclusive division consisting of 2 judges exclusively dealing with intellectual property matters in the Delhi High Court. So this is as of 28th of February, almost like 1st March 2022, and it's been 1.5 months since the IP division of the Delhi High Court has been functioning, and we are seeing great challenges being mounted in the IP division, but I think the foundation and the structure has already been put in place, and I think that it is, while we go forward with this IP division, we are seeing, at least in the last 1.5 months, greater consistency in the kind of judgments that are coming out. Mostly even on procedural aspects, there is complete, if you say, kind of clarity which is there for the litigants and for lawyers. A number of rules in the Delhi High Court, IPD rules. For example, if there are 5 or 6 cases related to the same patent, there is a power of consolidation of that. So the court can actually say all these 5 cases will go together, the trial will be common. So this is one rule which is really proving to be helpful. Another rule, another issue that we were facing is, in the district court there is a suit for infringement, in the High Court there is a rectification. So those 2 can be consolidated by the Delhi High Court and brought together. We are also in the IP division dealing with not just original proceedings and suits, we are dealing with appeals, we are dealing with writs, we are dealing with revisions. So the IP division is now an all-in-all IP court where all issues relating to IP are being adjudicated. No longer different courts adjudicated. This is a very unique system because the IP division has writ jurisdiction, appellate jurisdiction, original jurisdiction, revisional jurisdiction, which is completely unheard of. If you all know what I'm saying in terms of the Code of Civil Procedure, it's completely unheard of. So this is happening only because the IP division has been set up to deal exclusively with IP matters, and it's functioning smoothly. I mean, I shouldn't be saying about it. I think it's the lawyer community and the litigant community which should speak about it. You will all be surprised to know that the IP litigation landscape in India has changed completely over the last 20 years. Initially, sometime in 2000-2004, between 2000 to 2004, for example, in the Delhi High Court, we had about 2,000 IPR cases, out of which the maximum were of trademarks, and patent cases were just 3 in those 4 years, 5 years. Only 3 patent cases were there. Then it became, in the next 5 years, it was 13. 2010 to 14, we saw about 61 patent cases. 2015 to 19, 179 patent cases. And 2020 to now, in the pandemic, it's more than 130 cases in just 2 years. So the IP litigation landscape is completely changing in India. We are having more and more patent litigation, which just shows and matches up with the innovation that's happening in India. I did read about the recent reports about how Indian filings have surpassed the foreign filings in India in the last quarter. It's happened for the first time. And earlier, I remember when we used to take out statistics, prior to 2015, the statistics were for trademarks, 80% domestic, 20% foreign. In patents, it was the exact opposite, 80% foreign, 20% domestic. And when we reviewed, for the purpose of this seminar in March, the filings had come up to 60% domestic, 60% foreign and 40% domestic, which was still 60-40. But in the last quarter, domestic filings of patents have surpassed the foreign filings, which I think is not just an ordinary feat, because for domestic filings to surpass foreign filings, India has had to have this entire movement surrounding around innovation. And that's happened due to various, starting with the IPR policy and various other steps, etc. So I think as filings increase, as administrative exigencies are also being taken care of. There are challenges which we are facing, so IP adjudication also has to be streamlined. There's a recent parliamentary committee report which has recommended IP divisions in all high courts in the country as of last week, to be followed on the model of the Delhi High Court. And that report actually says so, that we should, because in the earlier report 6 months ago, the parliamentary committee had said we should reset up the IPAB, but then that recommendation has now been reviewed and it is being changed to say that we should establish IP divisions across the country in all high courts. We should have exclusive IP divisions. And I think that IP adjudication going forward is going to look completely different. In the IP division, we are now looking to recruit engineers, scientific graduates, science graduates in different fields of science to be able to help the judges on a regular basis. We have law researchers who help us regularly, but now we are going to have law researchers who are also science graduates. You could call them scientific researchers or whatever. We are also hoping to draw up panels of experts, and hopefully this panel of experts which the High Court, the Delhi High Court intends to draw up, should be a panel which can be used by high courts across the country. And if we have a panel like this in any court, in any high court, if there is an issue, let's say about telecommunications, about electronics, about biotechnology, about biochemistry, the court can look at that panel and call for the services of that particular expert, and then he or she can be asked to give evidence, can be asked to give a report on the patent. So it can be of great use for the judges who are not scientifically qualified people. And going forward, we imagine that this kind of a help for judges in the IP division will be of great assistance, so that we get our own independent inputs from these experts and researchers. And the Delhi High Court is in the process of going to recruit these kind of scientific researchers for helping the judges in the High Court, both at the IP original level and even at the appellate level. So I think I have passed my time, it's 20 minutes. This is all that I wanted to say in terms of the IP division of the Delhi High Court. I really think that with the growing innovation that's happening, the fact that high courts will be supervising the patent offices and trademark offices, I think is a good thing, because there was this, whenever there's something happening in a court, there's a lot of accessibility and transparency, because the bar is there, it's an open court, everybody can see. Most of our courts are hybrid. Anyone from anywhere in the world can sit down and watch the proceedings of the IP division on a daily basis, morning to evening. So it creates a huge amount of goodwill and equity within the IP division and the court system in India, so that, litigants from across the world and in India are sure about the transparent systems that have been adopted, the procedures which are globally recognized. We have features of hot tubbing, we have features of local commissioners recording evidence, we have VC facilities now in the IP division in the Delhi High Court. So, I mean, I know even as on today, there was a lawyer from Chennai who logged in and argued in a matter. So it's not that we're going to shut them out. We can definitely have even independent experts appearing online and clarifying queries to us if we want. So the whole ecosystem due to the pandemic has changed. And for example, there are issues where there are oppositions in the trademark office which are pending, which are all, I think, going to be under the supervision of the High Court, and of course with the new Controller General who is coming in. We expect that there should be several steps which would be taken for streamlining the administration, and there's also a hope that we can have some kind of a mediation in intellectual property matters in the trademark office level and in the patent office level, where there can be a parallel, mediation kind of center which can be run there, so that not every case needs to go into adjudication and adversarial system. You know, you'll be surprised that in the Delhi High Court Mediation Center, in the last 3 years, the intellectual property matters which have been referred have had such a whopping settlement record. You will be surprised. In 1 year, it was actually 100% in 18 or 19. 100% matters which went to the mediation center were settled. So over the last 5 years, the actual average is much higher than commercial disputes and civil disputes. So the average of settlements is 85%. So 85% of cases which are referred to mediation are getting settled. It just shows how, positive attitude of the bar, of the litigants, of the judges and of the mediators as well. So it is an amazing statistic that 85 to 100% cases can be settled. I think that is a good model for someone to think of even in the trademark office level and in the patent office level. So every day there are matters which are getting settled in courts, and I think that India is on the cusp of a big IP revolution in both adjudication and in administration, and I wish all of you the very best. We are approaching the World IP Day next week. The theme this year is IP and youth.